Here.
Alex Sharp, I'm here. David Connick.
We have to start over because I was
Okay. Jennifer and I are here. David Connick.
And
Ron Mack. Christopher.
here.
Okay, everybody's here. Second item is to adopt the meeting agenda. Are there any changes, additions, deletions?
I move we adopt it.
Is there a second?
Second.
All in favor?
Aye.
Okay. Next item is the minutes from the July 24th meeting. Have those been reviewed? I was not at that.
They have been reviewed and there was one or two
I mean, I
typos.
wasn't.
And the couple typos were fixed. There was no substantive thing. And so I move that they be adopted as corrected, as circulated, and then minor corrections of typos.
Is there a second?
I'm the secretary, so I'm not going to second it.
I wasn't there.
Second.
Okay, all in favor?
Aye.
Okay. And the next item is the proper wording continued or
Yes.
or recessed? It was recessed,
It was recessed.
or the hearing was recessed, and now we're continuing with the revocation hearing for the Harmony Manor Bed and Breakfast. And I was not here, but I feel like I was because I just finished the video. So I've got a fairly fresh idea.
Local red button press?
Yeah. That's the last time anybody who speaks, they would give them a name. It's an,
Oh, just a minute, you have to swear.
not you guys, but it's an unusual meeting.
I guess.
Swear that you'll,
Do you swear to tell the truth, the whole truth?
No, not that. You swear that you'll accurately transcribe these proceedings to the best of your ability.
Yes, I do.
Okay, if you have an unusual name, you're supposed to spell it, so that the court reporter can make a record of that. Okay. Now, we did have a public hearing. I just want to understand if I'm correct on this. There was a public hearing last time, and the public hearing was closed.
Well,
Is that correct?
I'm not sure if we recessed it or closed it, but we did make some comment that since the permit holders were going to file some additional materials, that if anybody had any comments or something, or they wanted to amplify their responsive comments, I think that we're sort of open to that.
So we would do that probably a little bit later.
Yes, but we did get to the point of making motions in regards to
The application.
yeah, okay.
No,
Or
he made a motion.
for the public hearing information.
You got to the point of a motion being made to revoke the permit that was not seconded.
Right. So
So does that mean?
sort of a anomaly, but then the motion to continue the meeting was subject to them providing the additional materials and also subject to people from the public that want to comment, to comment.
And the materials, the lease was one?
I think the lease was in, well, it was the records of who stayed there and when,
Oh,
and so that's right up here. I was circulated electronically.
Yeah, that's
also.
awesome. okay. And so have people gotten a chance to see that?
On the board, yeah.
On the
I'm
public?
not sure if the poll, I guess, was on the board doc.
Okay.
Yeah, it was posted the board doc.
Well, my perspective is, first of all, I just have a couple of questions that occurred to me while watching it. So I'm going to take the liberty of asking the applicants, the permit holders. Oh, yes, thank you. Okay, so the question that I have is, you were leasing out the parts of the main house to your other entity?
That is correct.
Okay, and that included not only the basement, but part of the first floor,
The entire first floor.
the entire main level.
That's correct.
Okay, and so what is left what is left for the bed and breakfast part would be simply the 4 bedrooms upstairs?
That is correct.
That's all?
And the fifth on the outside of the garage.
that's a totally separate entrance
Yes, it
for
is.
that fifth one? Okay. Okay, and so previously, the bed and breakfast would have certainly had the guests spending time in the living room, sitting room, kitchen,
Yes,
front porches.
that is correct.
So what is different about that now?
Nothing.
What does that mean?
That means that the guests who are staying the night can roam the house at will.
Okay, so what else is being done with that space if it's not being rented? I mean, if it's being rented to.
If it's being rented, we're using it as wine tasting space, specifically the basement, and there are classes that we hold on the first floor, mostly in the living room, or in the dining room, sometimes in the kitchen, but mostly in the dining room.
Okay, so you've gone from exclusively for the bed and breakfast to shared space?
That is correct.
Okay. I think that's my main question. Is it?
The other thing here, Mr. Chairman, is that gentlemen from the highway department are here to discuss the entrance. We invited them, so that was another purpose of, so they were,
Okay.
Mr. Nesbitt's here and.
Okay.
From the
So,
highway department, so I'd rather hear from them, whatever they have to say.
okay. Well, I'd be interested to hear from you guys from the highway department. You have something to tell us? Or
Well,
you could identify yourself.
yeah, I'm Mark Nesbitt. I'm the resident engineer for DDOT Norton office, and I have folk up for Rappahannock and Albany County. I have Joe Webb, who is my land use engineer here with me, and who works on these types of matters on a more regular basis than I. But yeah, we've got a request from Mr. Connick several weeks ago to review, some information on these zoning issues. And we're basically here to answer questions. I really don't have a statement to make. If there's a question that the board has regarding whatever proceedings are, we're here to respond and try to answer the questions you may have.
Well, I guess my question is, there's some confusion, I guess, between the letters that were written back when the first permit was issued and then after the second permit was issued or when it was pending, and how that applies to the current use. And it's my understanding, which I guess I would like to hear from you on, is that was limited to the use of the property as a 3-bedroom B&B operation. Is that right?
That's our understanding, yes. It was I think it was approved for a 3rd bedroom use. And that's what, the review was based on, sort of a minor increase in traffic, that entrance would be sufficient for that minor increase in traffic.
So the,
Yeah.
so the, okay, so the increase due to the space becoming a winery slash classes.
I don't think that was a consideration at that time.
But would that be a consideration now if it were a new?
If that were the a use, that proposed use for that was being applied for, we would certainly look at that and we would ask for the pertinent information as far as the size, the type, the hours of operation. There's a good bit of information that we would need to make a decision on that use.
So an estimate of the traffic
Correct. And,
count or whatever.
yes.
And have, since your last letter, I mean, in 2013 or 14, I don't have it right in front of me right now, but when you reviewed it in connection with the 5-bedroom B&B, has Harmony Manor B&B LLC or any agent for them asked or applied for a different entrance permit? They asked you to review it?
Since 2013, not that I'm aware of. Nothing we had.
Nothing in the last couple of years.
No.
Okay.
And so nothing in connection with it, one of the issues, I guess, that's been raised, I'm not sure if it's really before us, but it's whether or not the property can be used or is exempt from zoning because it's of agritourism. It's one of the uses, I think, under Virginia Code 15.2, 2288.6, I want to say. So the question is, does it's my understanding from your recent letter that the entrance does not meet those standards.
Well, the agribusiness standard is, I think it's 50-foot radii and 30-foot width, entrance width. So if they came, to the county and to VDOT with that use, then that was what we would apply it to.
So would it meet that standard as it currently is?
Not as it currently exists.
And have you been out and done your own measurements? Because from the 2013-14 letter, it was, you were looking at aerial surveillance, and then some from the local folks who have done some. So have you actually been there and surveyed it and taped it and measured it?
We're not set up to do that level of review. That should be provided by the applicant.
Mr. Orr, did the gentleman who didn't review the application, did make a site visit?
Back then or
Back then.
So a review request should have been made by the applicant, the person, the business owner, or this,
Yes.
okay. And then was made recently.
Not recently.
No, this was back in 13 and 14 when the application was under review.
Any,
Yes, can you differentiate between the deceleration lanes, as you come down 211 approaching Clark Lane, there's a deceleration lane for the Quickie Mart gas station. It skips over the co-op and Clark Lane. Then there's a deceleration lane for Mountainside Therapy, and then there is a deceleration lane for Christmas Tree Lane. There are businesses in all those locations. Why are there deceleration lanes for certain ones, but not Clark Lane?
A lot of it would depend on when that entrance or business was developed. Standards change, entrance standards and access management standards change over time. And more your recent development, your convenience stores, gas stations, traffic generators, in recent, probably, I say recent, I mean probably 20, whenever access management standards were developed, probably, 20, 30 years ago, 15, 20 years ago.
Other current ones are 2010 as well.
There are standards for deceleration lanes, which didn't exist. I'm just assuming that some of these other businesses or some of these other entrances were constructed. Some of them may have been there, for years as farm roads, and slowly the uses have evolved over time. But just because there's a driveway or entrance there doesn't mean it's going to have a turn lane. It just depends on when it was developed and what the requirements were at that time.
But one would think that in regards to repaving operations which have gone on 211, in the past or whatever, that deceleration lanes are safety factors. And so they should not be a grandfathered option. In that the co-op is probably one of the busiest commercial areas in Rappahannock County. And yet there is no deceleration lane there, and there's plenty of space to put one in. It has just never been put in.
you're talking about at Clark Lane?
I'm talking about at the co-op,
Oh, at that.
which also could easily be continued to Clark Lane because of the proximity of the two locations. But to me, I mean, it's like you can't go, well, we didn't put that one in because they've been there a long time or whatever. It's a safety feature. And it should have been, at some point in time, incorporated into paving projects that be put in. Because like I said, you've got one at the gas station just previous to it, then it stops, then it starts again at Mountainside Therapy. But looking at it rationally or whatever, that doesn't make any sense.
Yeah, it may not from that perspective, but if you look at it from the road is a 4-lane divided highway, there's 2 lanes. It may not even, with the volume that it has today, it may not even meet the criteria for a turn lane. Without that, there's volume criteria, number of right turn lanes versus the number of amount of traffic on that road. There is set criteria for turn lanes. But VDOT, we're really not funded to go and add turn lanes on our resurfacing projects. We're there to maintain that form, the existing paved section. And if there is a turn lane that's already built, that's built, we'll overlay that. But as far as constructing new turn lanes for businesses, that's not standard practice, and it never has been.
But you found the money to increase the deceleration lane on 211 turning on to 522 to Flint Hill.
Right, that's a state, those are 2 primary roads and 2 primary roads. It's a lot different than a private business. So, yeah.
Okay,
I think we did find the money for that.
I think we're okay with that explanation. Is there anything else?
I wanted to know, what is the threshold volume that you would need to, that a owner would have to put a deceleration or turn lane in? Is there a specific number of vehicles coming in?
Or a number of houses?
It depends on the peak hour volume of the advancing traffic on the highway in comparison to the peak hour volume of the right turns using the entrance. And there's a graph where determining whether they need a taper or a taper and a turn lane. So we need those numbers.
What's the difference between a taper and a turn lane?
The
Those who
tapers-
don't know.
The taper is the triangular piece you're using to merge into the turn lane.
The turn lane has a storage link, which is a parallel section that you can pull in and turn. The taper is the transition to that turn lane. If it's, depending on the amount of traffic, it may just require a taper, that transition taper. If it's, a more significant amount, and it varies depending on the volume of the road that you're putting it on, whether it requires a storage lane or whether a taper. Sometimes it doesn't even require a taper. So it just depends on the amount of volume that you're generating, the amount of right turns that you're generating.
And the taper's not part of the radius.
What's that?
Is it, there's a taper,
Taper.
and then you've got the radius, and they're not,
You've got the taper, you've got the storage length, and then you've got the radius. There's 3 different pieces.
The taper is either going to lead you into the radius or lead you into the storage.
Okay, but upon request, you can make that determination,
Given the, yes,
given the information.
given the information.
Okay, but you're not doing that tonight?
No.
Okay. Is that enough for that? Okay, thank you very much.
Can they go if they want?
You can,
May I ask some
Oh.
questions?
sure, well, go ahead.
So,
And you're identifying.
I'm Brian Prater. I'm here on behalf of Harvard Manor D&B. Vineyard Inn. Earlier you said that VDOT will review an entrance when there is a proposal for a change in use or change in zoning. Is that correct?
Yes.
And when the use is permitted by right, does VDOT have a proposal circulated to its desk or table to review?
Depends on what, typically it would stem from a rezoning or some sort of action with the local government that would initiate that.
Okay. And so during permissible uses, when it's a permitted by right use, VDOT typically does not get involved in those instances if it's not seeking approval from whether administrative or from a local governing body or BZA?
Yes, we review applications for by right permitted uses.
You do?
If there's brand new permitted use that needs an entrance on the highway or redevelopment of existing by right use, that application should come through the locality to VDOT for review, and then we would send our
Okay.
comments to the locality.
And if the locality does not require any sort of application for that use that's by right, would there be any reason that it would get to your office?
For like a special use permit or?
No, just it's a by right use that does not require zoning approval.
So in other words, nobody calls you, are you gonna?
Probably not, we don't go out and look
Okay.
And if they're,
We don't have any by right uses in our county that don't require a zoning permit. All uses require a zoning permit, whether they're by right special use permit or special exception permit. They all have to come to the zoning administrator and get a zoning permit.
But that has not been the practice.
I don't know whether it's been a
I
practice.
will point you to zoning ordinance 70, 137, I believe is the section.
No, I think you ought to take a look at 170-16 and read it. That's what I was just quoting from.
Okay.
But 130, and it's cited in the memo that you read, 70, 137 states that by right uses that do not require site improvements or health department approval do not require a zoning permit.
Okay. So.
And anyway,
One example I guess I could give is,
No, it's all right. You got to say.
if, for example, there's an agricultural use that the county doesn't have purview over, and the owner wants a new entrance on the road, they are supposed to come to us for a land use permit to put a new entrance on the road.
but if it's an existing entrance, that leads to a private road, and the entrance to the use is off of that private road,
I think we understand. You would not find them and go do an analysis.
So we would rely on the locality.
Yeah, the county has to, okay.
and then my point to that would be that VDOT does not dictate the land use of a
I
locality.
think we understand.
Okay, and
No, we
then,
do not.
and then I would just, to be on the record, just reiterate that a deficiency of an entrance standards by VDOT standards does not prohibit a use, permitted use on the land, nor in this instance, since we're here to focus on whether or not Harmony Manor is in compliance with the terms of special use permit, or whether or not the special use permit should be revoked. The entrance does not pertain to what we're here tonight to discuss.
Possibly. I mean, I might agree with that. But we still have more to talk about.
I understand that.
Are you done?
I am done,
Okay.
thank you.
Okay, are we done with that, I guess?
We're finished.
You have something to say?
No, I was saying,
Thank you.
thank you.
Oh, you're waiting a lot?
You know where to find us, we can.
We know we need
Go have dinner now.
I will forward the right turn lane warrants, Mr. Collins has an email address, so we can share it with the board.
Okay,
Thank you.
thank you very much.
Thanks for coming, I appreciate it.
Okay, so let's see, what is the other information? That we were getting 3 bits of information.
We were getting the usage
The usage.
from 2012.
What was the other? There were 3 things that,
Oh, excuse me, so we're at what point now?
there were 3 items of information that they were supposed to bring forward to us. The highway department was coming and we talked about it.
Correct.
There's some information about the usage, but I don't even know if we need to get into that or not. And wasn't there a third? Maybe there wasn't, but I thought there was a third.
Winery use, that was discussed, that
I think Ron was gonna check with ABC.
Did you?
Yes, and basically, I checked with ABC, and the information I got is interesting, but quite honestly, at this conjuncture of where we're at or whatever is not really relevant. So I don't think that it's worthy of being discussed at this point.
Okay.
Because in the original permit, the point was that there was not to be large spaces in the Harmony Manor were not to be used, were to be left alone, except for people who
What
wanted
is
to
a
have.
large space? You mean
Well, that's-
outside or inside?
No, it was inside. It was,
I guess maybe, Mr. Chairman, the other thing that we continued the meeting for is to give the members a chance to review the transcript of the original hearing when this was approved January 25th, because as of last week, we weren't here at the June meeting. I don't know, for whatever reason, and I suspect the reason was that the case was appealed, so it went to circuit court. And there weren't any actual minutes of the meeting. There was just something in the minute book that said, see the attached discs, but the discs weren't there. So I deduced that I bet they're over in circuit court when they sent the file over when it got appealed. And that appeal was, you may recall, was dismissed on procedural grounds, but they were still in the file. So I located them, but only the day of the meeting. And I borrowed them from the clerk, and we were going to have them transcribed, and then it turned out the next day, I'm not sure how, but Michelle Summers found them somewhere in the zoning office. So in the meantime, they got transcribed and they were circulated to the board, and that was, I think, maybe the third thing you're thinking of that we were going to do in the interim.
well, the condition 2 of the original permit was that no for-profit events or rentals of other spaces in the structure or on the property. And so that was one of the questions that sort of brought in about the winery, because they're having educational points with the wine tasting, wine mixing, and so forth. And so that was something that was discussed, and we wanted to go back to get the original transcripts to look at that, and it came through loud and clear that there was to be no for-profit events, rentals, etc., and use of these larger spaces.
So you basically have a permit that was given under certain circumstances, and the circumstances have changed because of the new uses. This would be my view of it. And so you have you do have a different situation now, because you have a winery or whatever it is sharing space that was originally bed and breakfast space. That you would probably acknowledge that.
And we do acknowledge that.
Yeah.
But I,
Okay.
But you're leasing, the Harmony Manor is leasing to Skyline Vineyards,
So
Little Washington.
Little Washington
But
Vineyards.
yes.
And so that is for profit.
So it is a different, there's been changes.
Mr. Chairman?
And there, hold on just a second. There was a reference to somebody talking about what could happen if a winery was not applied for, but just done. That being a pretty good site for a winery, I would say.
This is,
Hold on.
Okay.
And so basically that was back, I think, at the original meeting, and I recall, because I think I was the one who made that comment. When everybody was so concerned about, the bed and breakfast and the amount of traffic. My comment was, well, there are uses that are by right that are way more invasive. And I consider a winery, I think wineries are great, but I think it's a way more intensive use than a bed and breakfast. So that was me, I'm pretty sure that was the one commenting on that. So I definitely was in favor of the bed and breakfast, and I thought, I mean, I know others didn't, but I thought it was a reasonable location for it. But my personal opinion is somewhat modified now that it's got all this other use piled on top of it. And I think, I'm just stating my opinion, that I think that does significantly change what you're doing, or what your clients are doing up there, to the point where I think it should, however it needs to be done, be reviewed or whatever we're doing tonight. Yeah, you're welcome.
if I may.
Sure.
And I appreciate your change in feelings and how you felt in 2012, I believe it was, and now. And my response to that would be that this was before the BZA, and those concerns were expressed. And the BZA had the opportunity to make express conditions if they didn't want, because the special use permit runs with the land. And the express terms of that permit controlled the use that was permitted by that permit. And if and does not affect the by right uses that are on that property, that are permitted on that property.
I'm not sure I understand how that.
Okay, but the special use permit had express terms and conditions. And the BZA adopted those and issued that permit for the bed and breakfast. And the BZA had the opportunity.
These are not to be rented out and not to have events.
Correct. And there are other, as you heard, you just watched the video, my arguments
Okay.
with state legislature preempting the local localities on farm winery and agritourism. But my point being that the express language does not prohibit a winery, or a farm winery, I should say, of the special use permit. It says no events or no rentals. Similar with the traffic and the road, the BZA had the opportunity to prohibit a certain number of trips per day, or make the landowner pave that road or maintain that road in a certain condition, and it did not do that at that point. And it's not, the BZA is not able to forego its failure to consider future conditions and punish a subsequent landowner by revoking a special use permit of which the terms and conditions we submit have not been violated, or they are in compliance currently with those terms and conditions. And I can clarify, I know that was a lot, but I can clarify that.
There was a lot of discussion about the use of the road, condition of the road at that time, and it's not been improved very much since then. And that Mr. McCarthy at the time, the county administrator and zoning administrator at the time, said, how am I going to go out there and count the number of cars coming up and down the road? And that was the gist of what he said in there. And so I will say he tried to dissuade some of the arguments that the Board of Zoning Appeals was making, the members were making at the time about, well, could you repave it? Could you do this? Could you, do other things in order to improve it? And the courts said, no, I mean, the cost would be prohibitive. And when we said, well, can we limit the number of cars or to whatever kind of thing? And we were dissuaded by Mr. McCarthy. Is that correct?
And that is to my point that.
So, but I was not in favor of that because of the safety issues that were there.
And I understand that, and at that time that was the opportunity to either deny the permit, not issue the permit, or issue it with specific conditions that prohibited certain things.
Now, I would also venture to say that on the second application that went from 3 bedrooms to 5 bedrooms.
It was 2 to 3 with an option for 4 and 5.
Well, I mean, but we did grant subject to getting these turnouts put in.
Correct.
5, yes.
Correct.
Okay, and I think Jennifer was operating, I recall you were the one who came up with that concept of the turnouts.
Right, I did.
And because you felt like that would accomplish.
But I don't know that if they really followed through as thoroughly as what.
They didn't put them in time. And they got a ruling from the zoning, or I guess you'd say ruling that they were not timely installed and that the permit was no longer active for the extra 2 bedrooms.
Correct.
And so that was appealed, but they dropped the appeal.
Right, they withdrew the.
They withdrew the appeal. So there was nothing that ever reversed that, so basically it is the 3 bedrooms.
Correct.
But my point being that I think part of the reason that that extra 2 bedrooms was granted, at least in Jennifer's case, was because you relied upon some steps being taken to make the road more safe.
Right.
So,
And that's true, but if things
and
are
that
followed
did
through and if
not-
they're done half-heartedly and not fully done, then, and, you
Well, I'm not
know,
arguing with you, I'm just.
then that's,
yeah. Yeah.
just not showing good faith.
So where are we here? What are we doing?
I'm currently,
Okay, now do we need, I mean, I don't feel like we necessarily need to open it to the public, but I mean, do we?
That's up to you.
Well, I mean, we left open any comments about the
we
new
had the
information.
public hearing.
I know, but when I listened to the, there was some question raised about did we give the public another opportunity based on the new information? I'm suggesting not, but I'm just bringing it up.
Okay.
Is that anybody's pleasure?
Yeah, we've heard from the public.
I think the attorney wants to say something.
I just, in going through the transcript in that motion, one of the aspects of, we were given a deadline to get some time, some records in, were for the board members to review, but also part of that was for the public to review.
Right.
So having reviewed it, do you think the public has a right to comment on it now, or are
I
you
think
just got to
they-
review
I
it
think
and
they
just
may if-
come here and
if they
watch
want
what
to.
happens?
I don't feel,
I think they should, but that is my opinion.
so what I would just put that to the board members, yes or no?
Well, I guess before I voted on it, I guess I would like to see a show of hands if there is one. Is there anybody in the public that we don't want to hear the same stuff we said last time we heard that?
Just
Loud and clear at least. And is there anything that anybody wants to say based on the supplemental filing?
Just the new information.
Just the new information. Does anybody have anything they want to say in response just to that?
And that was the,
Or anything that the highway guys said, which basically was they haven't reviewed it. So.
that was the number of guests that were there from between 2012.
Or the records, right?
So we got those records.
So that's
So,
about it.
no.
It's pretty limited. Is
No.
there anybody that wants
Yeah,
to?
the records.
Does anybody want to say anything about any of
There's
it?
a gap in the record, so it's not relevant.
But this,
Please, I can't, it's too many people talking.
What's the limit?
is this related to the new information?
To the information that the VDOT people
Okay,
sent.
I guess, go ahead.
Okay, my name's Brian Schultz.
I guess I'm.
When VDOT originally reviewed the Clark Lane and the co-op entrance, at that time, there was an entrance and an exit for the co-op. Co-op now has that as exit only, no entrance. That may change things.
Could I ask you a question? Because I don't recall, but I know you live there, so you do. When the co-op moved there from Sperryville, wasn't it still a 2-lane road then?
I believe it was.
It wasn't 4-lane yet.
Yeah.
So
Wait, where did the 4 lanes stop?
where did the 4
Did
lanes
it stop at Little Washington?
Yeah. It stopped right in front of Regner's,
Oh, okay,
right? That's my recollection, and they built they
He's-
dual laned it from all the way down,
He's
from
old.
there all the way down to
okay.
Sperryville, to where it narrows down now, where they just fixed the bridge. That's the part they put in 1992.
Okay, okay.
So the co-op had already moved there, and that's why they wanted the decel lane, because it was still a 2-lane highway.
And because that building had been there for a long, since when, the 40s or something. You were probably there.
No, the building, all I'm saying to that is the building was already there when I arrived in Rappahannock.
Okay, see,
It wasn't the co-op.
I just remember the original discussion was, if it's safe enough for people to go in and out of the co-op, it should be safe enough for Clark Lane. When people do not go in and out of the co-op,
right, they just.
they don't decelerate at that
Just
point.
go out. Okay, okay, that's fine. Go ahead if you.
I just have a question about the materials that were provided to the BZA, and are those incorporated into the record?
Well, if they're not,
Yeah.
let's do that.
Could we do that? Thank
So that would be Mr. Prater's letter of July 26th and the voluminous attachments.
You have,
Which includes the
Okay.
transcript, right?
She has stickers.
Transcript and all that, so, go ahead, yeah, that was her number.
And then,
I don't have to carry it
I
around.
believe the VDOT information was in that memo, but just to make sure that's in there, and the records.
okay, okay.
Now, Ms. Barsky sent something in that I submitted a written thing that I sent around, so do you have that printed out?
Thank you.
Do you have a copy that we can give to the court reporter?
Oh, wait, did I?
Oh, paper copy, no, I have a shorter version. I don't have the full version.
Does somebody print it out? I mean, we can,
I read it,
I
I
think
think.
we can.
I just read it online, I don't have a color printer, so.
Yeah. Is there anybody else who wishes?
Look at that.
This nice lady has
There's somebody up here.
one. What exhibit are we up to?
Have you been to the beach or
We
something?
haven't started. We haven't counted them.
What do you?
That's the last.
Okay, is it anybody else in the
Yeah.
public, so, and you're speaking on these latest information? Okay. Oh, hold on.
There you go.
Okay, well, I got the
How do you want to do this? Because you got the transcript and you got the record.
Right, I think it would be helpful to take the transcript out and make it a summary exhibit. And I have a full copy of the
We're going to
transcript.
go off the record and take a little break so he and I can straighten this out.
Do we just turn these things off?
They say to just let you do it for 5 minutes, they let you do everything.
All trees down there.
Okay, we're going to take just very brief, but we'll get to you when you finish. We're going to take a brief recess while they figure this out.
Right.
All right, so pull down.
I have a,
Stretch.
this is the full copy.
Wait, 1 second. Okay, hold on, we're not making a motion just yet. We have one member of the public, Sheila. Would you wanted to comment? And if you could state your name for the recording.
Sheila Gressinger, Hampton District. My comment is based on the conversations we've had this evening. It looks as if this could be a win-win situation with items addressed and worked on as to how to make it work for the business. And since our comprehensive plan is based on agriculture and tourism, I think we want to be welcoming, and so we want our businesses to be able to go forward. So how can we make this work for the benefit of the county and for the business owners?
Okay, thank you. I guess no one else? Okay, thank you. I'm closing the public part of this meeting. Okay, so Ron, you're suggesting you might have a motion? Is that?
I'm not suggesting, I have a motion, a prepared motion, which I will distribute at this time to the members, and there are copies for some of the folks in the audience.
Well, now, is all
Is
of
there
this
enough, is
your
there enough for the recorder?
But this is the motion. It's 3 pages. And,
You don't.
oh, thank you, sir.
This is, this is the notes. It's not clear. Is this going to the record? Not yet, right? Not yet.
I'm going to read it.
I'm going to read the motion. Okay. This is a proposed motion, the motion for ratification of SUP number 11-12-02 and SUP number 13-09-01. Whereas pursuant to the authority granted in the Virginia Code 15.2-2309-7 and Rappahannock County Code 170-61, after due notice published and delivered by mail to interested parties as required by Virginia Code 15.2-2204 and corresponding provisions of the County Code, on June 26, 2019, the Board of Zoning Appeals for Rappahannock County held a public hearing to determine, 1, whether or not there has been non-compliance with the terms of the conditions of the special use permits issued by the BZA on January 25th, 2012 and October 23rd, 2013, including but not limited to Condition 1, maximum 3 bedrooms, 6 persons, as modified on 10/23/13, and Condition 2, no for-profit events or rentals, leasings of other spaces in structure or on property, and 2, whether or not to revoke either or both of the special use permits previously granted by the BZA to Randall and Kimberly Fort, trading as Harmony Manor BV LLC, Virginia State Corporation Commission ID number S399377, Carl Hendrickson, the registered agent, property address and location, Hampton District, tax map 28-52F, 65 Clark Lane, Post Office Box 198, Washington, Rappahannock County, Virginia. And whereas, after initial public hearing upon consideration of the testimony on behalf of the permit holder, the submissions by them and their counsel, the testimony of the zoning administrator, and the witnesses who appeared at the June 26, 2019 public hearing, and the review of the supplemental submissions by the permit holder, the transcript of the BZA proceedings in January 25, 2012, the testimony of the representatives of the Virginia Department of Transportation on August 28, 2019, and the arguments of counsel, the board makes the following findings of fact based on the substantial record evidence. 1, that the permit holder admitted that it advertised and rented more than 3 bedrooms for overnight accommodations in violation of condition 1, maximum 3 bedrooms, 6 persons, as modified on 10/23/13 on SUP number 11-1202. Ignoring a letter from then zoning administrator Debbie Kaiser dated June 26, 2016 that stated that condition 1 remained in effect. The permit holder only recently modified its reservation system after receiving a notice of violation dated March 6, 2019 from the present zoning administrator. 2, the permit holder has changed the use of the property since the issuance of the original special use permit and is utilizing it as both a B&B and a farm winery, and for purposes of agritourism, during the course of which there have been and continue to be for-profit events such as wine tastings and winemaking classes, which are in violation of condition 2. And 3, that the permit holder has leased a portion of the property to Little Washington Winery LLC for use as a farm winery and for winemaking operations, which is also a violation of condition 2. Number 4, that the traffic generated by on the access road by the additional uses is substantially greater than that contemplated by the board when the original permit was granted or amended in 2013, and the entrance onto US Route 211 has not been certified by VDOT for such additional intensity of use, and it has an impact on the public health, safety, and general welfare, including the safety and general welfare of the other property owners that utilize the access road in common with the permit holder, including the entrance with US 211. And number 5, that the permit holder has indicated an intention to continue to carry on these additional uses of the property, claiming exemption under Virginia Code 15.2-2288.3 and Virginia Code 15.2-2288.6. It is accordingly determined that the past and ongoing violations of the conditions on the permits warrant revocation of SUP number 11-12-02 and SUP number 13-09-01, and said permits will be hereby revoked effective December 31st, 2019.
Is that all? Is there a second?
Yeah, I'll second.
There's a second. Okay, now is there a discussion? Chris?
I question when the then zoning administrator, Deborah Kaiser, stated that condition 1 remained in effect. Was this property owned by the present owners or the previous owners?
Well, the record evidence is that the LLC owns it and has owned it since 2012 when the permit was issued. And they bought, the Hendricksons are new members of the LLC, but they bought the company that owned it. The ownership of the land and the buildings has not changed.
The title to the land is the same.
It's the same, they bought the company. So they're on
What-
notice
what I
of whatever was noticed.
What I am getting at is, were they apprised of the fact that they were in violation of the rules?
Technically, yes, because
Well, I
they,
mean, that technically is one thing, but
What do you mean by were they advised?
were they aware that they were?
if they weren't aware, they should have been aware. I mean, it's just like if you buy, I mean, that was, frankly, I see what you're driving at, Mr. Bernard, but I have to say that it wasn't our idea for this transaction where the Fords got out and the Hendricksons got in to the LLC. It wasn't our idea how to structure that transaction. I assume they decided to do that on advice of counsel. And so they've got to live with it, just like Mr. Prater said, and Mr. McCarthy said at the original hearing, the special use permit goes with the land. So even if there had been a deed and they sold it, if they're going to continue to operate the special use permit, it's their obligation to come in and get, or, find out what the conditions are. And had they done that, whichever way they bought it. But in this particular circumstance, they're stuck with the notice that was given to the prior managing director or manager of the LLC.
That should have been in the records of the LLC that
Well,
they bought.
there is the record that when apprised of the violation, they stopped violating. Well,
3 years later.
3 years later.
We're done with the public.
Okay, well, so here's another way of looking at that. At what point do you, and I'm just talking about this one point, if you find somebody to be in violation, you send them a letter, they discontinue that violation. I mean, do you then revoke the permit? And so that by itself would not be a reason necessarily to revoke the permit if you notified someone and then they comply, correct?
It depends on the facts and circumstances,
Okay.
and I mean, it's a theoretical question,
No,
a hypothetical
okay,
question, that
no.
I don't think we ought to be answering here.
Okay.
The fact of the matter
That's
is that they chose that way to do it, and all I could say, and
Okay.
I'm just speaking my opinion,
Point
and
one.
all right, it's my professional opinion, that if you buy a company and you don't do your due diligence and find out what all the conditions, it's not just some sort of remote possibility or whatever. If you're buying a real estate property, the main business of which is a bed and breakfast, you better make sure you have all the T's crossed and the I's dotted, and vice versa. And if they didn't do that, it's nobody's fault but their own, and I don't think it's up to the board to start making excuses for
I've
that.
got it.
Okay.
Okay, so the next couple of items, I mean, they're more of concern to me really is just the fact of the dramatic change in the use and the fact that it is no longer the space that was originally the bed and breakfast. That's really what I find to be more compelling really than this other part. But I'm not discounting it, but I'm just saying that.
I happen to agree with that. I mean, if that's all we had, if that was what we were here, and the only issue before the board was there was and given them the benefit of the doubt, that there was some confusion, quote unquote, of whether condition 1 applied or didn't apply, or how many bedrooms, and when it was brought to their attention, they corrected and stopped doing it. That's all that was here. I would tend to agree with you and say, well, all right, if you promise not to do it again, we'll continue this for 6 months or a year, and if we hear of any more violations, we'll see you again, otherwise we'll dismiss it, and that's that. But that's not what the circumstances are,
And I
in my opinion.
I also think that we've got a conflict between what the county ordinance can require in a special use permit, which is different from asserting it just on some landowner, versus this agritourism
In the states.
winery. So basically, I see a special use permit as an agreement between the owner and the county. And I see the conditions typically, especially if they're proffered by the owner, to be voluntary, not asserted on the person, because they don't have to get the permit. So, I mean, I do think that the county should be able to have conditions that can be relied upon. When they grant the permit, I don't think that can just then be yanked away. Yes, I think you're correct about the dominance of agritourism and wineries, but I don't think that is over top of an agreement that is made voluntarily. Because we didn't have to give this special use permit for a bed and breakfast. And these concessions were offered and accepted. And so I regard that as, that's one issue. The other issue is whatever you can do as a winery or agritourism, that's sort of your deal. But we're dealing with what we have been represented to us, what has been represented to us. And I feel like that's something that your argument takes away from us, or attempts to take away from us, and I don't see that as being something you can do.
So you would say that the concessions of not having, not leasing other parts of the property, and not having special events were binding conditions of the initial special use
I think there are
permit?
conditions that we can expect that would be followed and not just thrown out.
Yeah, I would say, yeah, absolutely, yeah.
I feel that way, because otherwise, what can we do? We can't. People can make conditions and say, well, do it, and I don't even necessarily agree with their conditions, but I'm just saying that they made them. And I don't know, maybe they weren't necessary to get the permit, but I think at least one member probably relied upon it to help them justify their decision to vote for it. And I feel like to be able to then have those just taken away, I don't see that as, I mean, I think that may be the issue here to me that's most important, is just, can we exact, I mean, somebody offers something to make us happy, and we say, okay, yeah, sure, if you're gonna do that, that sounds good, and then we grant the permit. And later on, come to find out, well, we don't deserve to be happy anymore. I mean, that's kind of how I feel about it.
There is a reason for the timing of the removal of the permit, and that is that presently there is an application before the planning commission at this point for a permit for a 5-bedroom B&B at this location. And that gives the Hendricksons 4 months for that, to follow that through. You know, they can negotiate a new, basically these two old permits with all of the new things that have happened have become, you know, it's not
Rats.
realistic to deal with it.
No, come on, Lorraine.
And so the best thing we can do is to start over again. And that option is on the table right now with the planning commission.
Which table it pending the action? that we
Correct. So they, you know, they have 4 months to renegotiate a special use permit that will meet their current needs, and the neighbors will have an additional opportunity to input on the current situation, because it is much different from what the, you know, when the original permits were granted. Basically, the original permits are outdated.
I'm agreeing with a lot of the conversation, and when we go back and look at what we were thinking about in 2012, the road needed to be upgraded. They were only planning on a 30 to 40% occupancy, maybe, you know, a couple holidays a year, it would go higher. And so some of the decisions were made on low estimates, and then the intensity has increased. And so these are outdated, and if they are revoked, then they can start fresh and get things in writing and come to agreements with.
It is not the intent to drive the Hendrickson's business out of the county.
No.
But there are problems with the way things are being done right now, and they need to be dealt with. And this is an effective way of doing that.
Okay, so were we to do this, I would be inclined to give them 6 months.
Why? It's already pending. It's going to come up at the September meeting.
Well, it sounds like it's going to be pretty contentious.
Well, it may or may not be, but it's going to come up for a review at the September Planning Commission meeting. And then they're going to have a public hearing on it in October, and we could theoretically have it before us in October, once the Planning Commission gives us their recommendation. So that's going to be at least, by extending it through December, that's going to give all of November and all of December. But if that's what you want to do.
And if it was to go over the 4 months, that's during the off-season, January and February, which really doesn't have, you know, as far as BMVs go, that's a down season anyways, but I don't think it would go that long.
So are you offering an amendment, or?
I mean, I'm suggesting just to make it September, February.
February 31st?
I was thinking the 29th.
It's not this year.
No,
There is Valentine's Day there.
February 1st, or,
No, there's Valentine's Day.
What?
I don't want to do it.
That's what make it January 31st. There's no meeting, so it's,
No, but
the
I'm-
January BZA, it's going to have to come back to us, so that would come
Okay,
out
so
January.
January 31st, okay. And then that would give you all time to really think about what you're actually applying for, because I think that's been a problem with this. Part of the problem was applying for a little bit and then coming back for a little increase, and then, you know, and all that, this death by 1,000 cuts kind of thing. I think if it's more comprehensive, maybe we can sell it better. Anyway, that would be mine, if you would agree to that modification. January.
If there's a second to it.
Well, I mean, you could resubmit that as your motion with that change.
You've got a motion and seconded, so somebody's got to second the
I'll second
amendment.
that motion of yours, Alex.
To amend it?
To amend it to the first of March.
And we have to vote on
First of
the
March?
Okay, what is it? We had
31st of January.
31st of January.
That's only one more month.
That's
Yeah.
Okay.
fine with me.
I mean, I don't know, do we have to vote on that?
Yeah.
Yes.
Okay, all in favor?
Aye.
Aye.
Okay, so now we got an amended motion, and I have an amendment to fix, looks like the third paragraph, the second whereas, third line from the bottom, it should be proceedings on January 25th, not in.
Okay.
That's a typo.
That sounds pretty important. Okay. Do we have to vote on that one?
No, that's a typo.
Okay.
Where's that in Robert's rules? If it's a typo, you don't have to vote on it. All right.
Okay, so we've made the motion,
You never asked me if I had any feelings about it.
no, I don't want to know your feelings. I'll talk to you. Is there, so we've made the motion and seconded, is there any other discussion? Okay, all in favor?
To revoke,
Of this motion, as amended.
as amended,
As
okay.
amended.
Aye.
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 Okay, so is that unanimous?
Sounds like it. Okay, everybody's gonna sign this. You fix the thing there. Who's got the pen?
Nobody voted.
Come on. It was here. I didn't mean to. Now my turn left.
Did you need a copy of the? I got it. And it just basically changed date to January 30th. Okay.
You gotta change this to 2020, right?
Okay, the next item
Wait a
on,
minute, let's go this.
we'll give you a minute to clear the room, but I don't even know.
Looking at this and saying, what is that thing? What is So your baseball career, NBA career is over? Your NBA career is over?
So you had a operation?
Be good.
Does it hurt? All right.
But only when you move it,
Okay, the next item on the agenda is a comprehensive plan. I don't think we have anything specific about that.
I guess not. I mean, you were at the meeting, so I guess.
Basically, the situation with the comprehensive plan is the planning commission finished their.
Okay. I should get a 9-pound gavel, right? What?
When you retire.
He'll never get one.
I won't be able to lift it.
Put wheels on it.
Okay. Maybe make an air operated one.
Whatever you.
Okay, I think we're ready now. Okay, so actually, if we could do the meeting. Comprehensive plan?
Okay, the planning commission has finished their reviewing of the comprehensive plan and sent it to the consulting firm that is going to write a note or do whatever else it was going to do. They were hired by the board of
We're
supervisors.
filling the gaps, that's where things are missing.
I think it's mostly just dealing with the things that the planning commission did, but try to get the language such that it would be conducive as a basis for a zoning ordinance. And there's going to be a joint meeting of the supervisors and planning commission going over this amended and worked on copy. And then there will be a supervisors meeting. In addition to that, that would be another month later.
So we're talking September and then,
I think at least September. I don't know the actual time frame. It depends on the group who is doing the consulting work on the planning commission copy.
okay.
But it's basically we were trying to get it so that the comprehensive plan would be finished and voted on this calendar year.
Is that
Actually, the consultants have 45 days to complete their analysis of
Starting when?
of the document. Starting when it was given to them on the, was it
It was
13th?
after the last.
Yeah, it was after.
planning
Oh, okay,
Yes,
so
after the last
probably
planning.
October.
And then we'll come back for, discussion or whatever. My personal feelings, which I think are relevant, is that because of the timing as far as the upcoming elections, that to have the comprehensive plan voted on after the election takes place in November would be not appropriate, because we will have new blood coming on with new thoughts, and the present Board of Supervisors had 4 years, 8 years, 12 years, 15, whatever it is, to push this thing through, and they didn't do it. And at the 11th hour to come through and make that vote, I don't think it's appropriate.
That's not really our call.
But
It's not our call, but that's
Okay.
my personal feeling.
Okay, well, we note you as being
Thank you.
opposed to the vote. Okay, I mean, that's probably enough, right?
I guess, till they come back, and then I think we ought to look at it and have another
Well,
discussion.
Absolutely.
we sent a number of things to the planning commission.
Oh, that's the May amendments.
No, no.
There's more.
The things that were in the letter that we sent to the
Oh, right.
planning
We sent a number of things.
Okay, no,
Are they, do you know if they've been considered and incorporated?
We had a list of, it was on the order of 20 or more questions, ideas, or problems that were dealt with by the planning commission. Gary Light was the one who codified them and acted, trying to organize that with the chairman of the commission. So that, I would think that they were dealt with.
Okay. We're good.
Thank you.
Okay, the next item is a letter we got from Beth and Paul Gall.
Are they here?
They're not here, but,
Good, let's invite them next month and talk about it then.
okay, well, anyway, I would say we would normally not react to such a letter, just because it's kind of a statement of, an aspirational statement about what we might like as in the family transfer ordinance, but we really don't have anything to do with that. Is that everybody's?
We don't have anything to do with it, but it needs to be pointed out that I think they do point out a shortcoming in the zoning ordinance,
So it's
along with the numerous other shortcomings that have been noted in years past but have not been dealt with. And it's just another brick in the pile or whatever of reasons why we need to reevaluate the zoning ordinance and bring it up to date
okay.
in a way that benefits, the citizens of Rappahannock County.
So we don't necessarily need to make a response?
No.
Okay, we've acknowledged.
Let's delegate it to Michelle.
I've already met with them, they knew there was possibly, no division rates left. So they weren't surprised by when we figured out that there weren't.
So you did figure that out?
Yeah, and this is just a letter expressing their concerns.